Lordship, I beg to mention for correction.
My lord, Subho Vijay, my lord. My lord,
Yeah,
extension of
all of
interim order, my lord. Interim order is expiring at the end of October, my lord. This one.
interim order expiring at the end of October.
Yes, my lord, this one.
All right. Who is your other side?
My lord, other side, my lord, I have sub notice to WhatsApp day before yesterday. My lord, Mr. Owen Banerjee and
Who is appearing?
Mr. Owen Banerjee for municipality and Mr. Nilanjan Bhattacharya, Vilas Chatterjee. My lord, I have sub
Can you
notice.
bring them?
My lord, I have sub notice to WhatsApp, my lord.
You have served notice. Can you bring them? Then I can take it up today itself. If you can bring them at 1,
Yes, my lord.
hand over the slip.
Yes.
If you can bring them at 1.
Lordship, may I permitted to mention correction?
From my officer, if you can catch hold of them,
Yes.
if they can come at 1 p.m., please tell my officers.
And my lord, matter was transferred to my lord, Supreme Honorable Justice Supreme Bhattacharya. My lord, some matters were transferred. My matter was included it. And my lord, last order was passed, my lord, on 20th September. My lord, and
20th of September.
yes, my lord.
All right, please come at 1 p.m. If you can inform them,
Yes.
please tell my officers. Yes.
Lordship, may I for correction?
Correction, hand over the slip.
Lordships, kindly, my lord, I'm seeking my lord leave to file without the certified copy. My
What
lord,
is the urgency?
I'm telling my lord, there's a misappeal against an order passed under Order 39 Rule 1 and 2. My lord, I have the certified copy of the misappeals order, but with respect to the my lord, suits court order, my lord, I do not have the certified copy.
They are not accepting.
No, my lord. They will not accept, my lord. I have my, I am telling you,
I'm finding many matters where the trial court certified copy has not been annexed.
that I am
Without
following what is
those
the
are the
procedure,
files.
my lord. If my lord kindly grants me leave, my lord,
Leave to file
My lord, may I
with the appeal court's judgment. Yes.
My lord, may I permitted to grant a leave to file this revisional application without certified copy? My lord, I have already
Why? What is the urgency?
urgency is, my lord, the compliance of the order is has to submit within 28th September, my lord.
28th September is already over.
28th October, my lord.
Do you have the server copy of the order?
I have the server copy.
All right, leave to file with the server copy.
My lord, may I have lordship's kind leave to mention a listed matter. My learned friend is on the other side. This matter has been settled, but it was a suit. There was a suit for eviction. They have vacated the premises, surrendered the tenancy, and I have got
It is
the
appearing in the list.
yes. I
Which item?
534, your lordship.
534.
534.
You are appearing for the other side.
I have written. I have instruction also.
534 of the monthly list.
I have. I have got the.
এটা বাদ করে নিন, এটা করে দিন। আসুন, item number 5.
For the revisional petitioner,
You are for the petitioner.
plaintiff
You
petitioner.
have handed over possession.
Yes. I am for.
handed over my position. I've handed over position to
My
them.
learned friend is a defendant.
I'm defendant.
Oh, he has handed over possession to you.
Yes.
Yes, my lord.
Mr. Menon, learned advert, this Is the date fixed? When have you filed? All right. Yes, call the list.
This is appearing at the instance of the Honorable Court, my lord.
At the instance of
The
the,
court, my lord, for a correction.
I have not detected any mistake.
We have not, but only thing, my lord, may I indicate to your lordship? 13th of November, 2025.
13th of,
November 2025, before the trial court, there is no stay of the order
all right.
or the proceeding. Now, the difficulty is section 34 application was permitted to be amended after 4 years after conclusion of that. So that issue has to be decided. There is one judgment in our favor, but your lordship was saying your lordship would decide the issue. So, my lord, if your lordship could keep this matter on the 11th, my lord, corridor news is your lordship is not sitting till the 10th. So, my lord, otherwise it would be infructuous, my lord.
Ashun. It has been. For the opposite party, yes. Opposite party is represented করে দিন ওরা রেকর্ড করে দিন মিস্টার গুপ্ত লানের অ্যাডভোকেট একটা লাইন রেকর্ড করে দিন মিস্টার গুপ্ত
But I appear for the opposite party. But would recollect this matter had been taken up on the last day before the vacation ensued. Lordship, they have come up against a order by which the consumer court has issued a non-bailable warrant against them. And we appraised your lordship that certain facts had been suppressed from the court. We filed a compilation of the serial of orders that have been passed in the matter. Repeatedly recalcitrant judgment debtor does not appear, does not file affidavit of assets. The lordship on the last occasion directed them to be present today with the affidavit of assets. They are not here. Around 53 lakh odd is due. Execution proceedings of 2016. Lordship would see the order impugned. The order impugned notices at least 5 dates he has been asked to appear personally, has not appeared. Not filed his affidavit of assets for more than 2 years.
আসুন pursuant to the order dated
Lord, I'm appearing for the petition. I'm being led by Mr. Devanik Banerjee in this matter.
You're led by?
Mr. Devanik Banerjee, my lord.
Yes, what do you want?
My lord, this has come up on court's own motion, my lord. This is for correction.
Oh, it has appeared for correction of a typographical error. It has been pointed out that there is next.
Item number 4.
The petition, my lord, I do not know.
Correction.
Yes, my lord, I.
Some disposed of.
Yes, yes.
Only the number of the civil division application was wrongly recorded. It has been pointed out that there is a typography. Yes, Mr. Rai, why orders?
Last order, you lost in the visitation, there is direction for filing of reports.
What happened?
It was held, but
Peaceful.
to some extent, not more or less. One thing I have done,
What was the impugner? So nothing remains.
no, report, that is why. On the other,
I am filing, I am giving copies to you.
yes, but on that one, some observation is required. Otherwise, I will not inviting a lordship to pass any order to.
Who is for the, you are for the other side. Where is Mr. Kolmokar? Please adjust your microphone.
Sir, Mr. Kolmokar sir is not present today.
Is not there, my lord. Yes,
You are the special officer. The advocates on record? No.
Yes, yes.
Sir,
Both the sides.
Both the sides. May later copy be served upon us also. So we'll come back.
Open করুন
দিদি জয়সাবকে দিদি
রিপোর্টটা হ্যাঁ রিপোর্টটা
do not have any access over their report is concerned.
No, I have
Direction for joint report.
officer.
That is why.
Then
That is.
where is your advocate on record?
Was appointed at.
Why have you not
Yes.
filed a joint report? I have asked both of you to file a joint report.
Report. It could have been one thing, my lord. So far the visitation is concerned, I am not.
Mr. Rai, who are you?
I am the
Petitioner wife.
petitioner wife.
Petitioner wife.
Yes, I have been.
Child was with you.
Child was with me. It was directed by your lordship that they will participate in the annual Durga Puja over there,
Yes.
and the wife will visit nearby accommodation. She went there along with the child. There is no
What
dispute.
is the difficulty, Mr. Rai?
Only one incident. I am not. So, but the other things I am not concerned. There is a sacrifice of the animal on the date, and it was forcefully the son was directed to be present in the spot, and due to that reason, my lord, the son is traumatized. If that be so, my lord, I have nothing to do. I will completely agree whatever because there's some. Let's just. I am not on that also.
That is indicated in your report,
Yes.
not in their report.
That is why, my lord, precisely, my lord, from there,
Which paragraph of your report?
my lord, can you turn to paragraph 13?
14, 15.
And photographs, there is some photographs also, my lord, I don't.
Yes, you are the advocate on record.
No, no, sir. I am the special.
Where is the advocate on record? Advocate on record is also not here.
Not yet come, sir. I am
Right.
waiting for that.
That is why, my lord, and the photographs, my lord, can you consider the photographs which are annexed in the report? Other things, my lord, can you forgive me or forgive us? Other, the order can be considered this in such a way detrimental to the interest of the minor. দিয়ে দিচ্ছে সব দিয়ে দেবে
Photograph. Where is the photograph?
last. And because of this, second photographs, my lord, will find this is the condition of the child. After
He was
seeing,
admitted. When?
no, yes, paint out and has kept in a room. That is the only incident, but that is what, my lord, precisely I am. So if I get access to the report filed by the,
ওদের বাড়ির মধ্যেই না প্যারাগ্রাফ 5টা শুধু দেখি
though they have stated it is their family native, but those are not the thing, it is a community puja. Be as it may, my lord, I am not of that.
All right. Community puja, they may be participating.
That is why, that is, my lord, that is what I am submitting. I am not uttering any sentence about the other things are concerned. So this incident and what happened after that, the boy is in a traumatized condition, my lord, still now is not come out from that state of affairs. More or less 70 or 80 goats.
Till now, this sacrifice is going
yes,
on.
yes, going on. And for that reason, my lord,
There's an order passed by the division bench
Bench.
PIL.
and also, my lord, the law says that you cannot do it in openly in the public places. And somebody at the age of this year is directed to be remain present during the sacrifice. Because I am not on that, my lord. Let me have a copy of the report, so I will come back to you.
Ashun.
That is otherwise, my lord, I will not press this application.
Yes. Now, how is the child?
Is not well. I have been instructed to submit these
Counselors are being consulted.
that is not going anywhere alone.
Psychiatric consult.
He is not willing to go alone. Even after evening, my lord, somebody has to stay sideways.
Psychiatric counseling is good.
May I get a copy of the report?
The reports filed.
My lord, this is a civil division application on the last occasion. My lord, you had directed, my lord had directed that affidavit of service be filed. We have filed affidavit of service. Brother. My lord, this stay is required to be extended, my lord, because during the moments of this stay, before the lower court, they had gone and gotten the suit dismissed for default. We had with great difficulty restored the suit in its original form. I will show.
Restored.
Yes, my lord.
Why it was dismissed for default?
My lord, our local advocate, he was indisposed for that occasion and for that. Now it has been restored, my lord, citing that there is a prevalent stay of the High Court.
আসুন
That I appear on behalf of the plaintiff petitioner in a suit for recovery of khas possession, my lord. My application under Order 6, Rule 17 has been dismissed. My application starts at from page 54.
At what stage?
My lord,
Argument.
Kindly see the schedule at page 55. What I want to implement, kindly see, my lord. Page 55, this is only thing, my lord, instead of 2001, instead of 98, I want to record it as December 2001. It is not
page.
Page 55 is my schedule to the order 6 rule 17. Instead of 1998, I want to make it at December 2001. It is not going to change the nature and character of the suit, nothing.
Show me your plaint.
My plaint starts from page 14. At paragraph 3 at page 15, I have stated that in the year 1998, Rajdev Mullah died. This was controverted, my lord, at paragraph starting from paragraph page 23, paragraph B, my lord, will see this is their reply.
Page 23,
paragraph B of the written statement. The present answering respondent defendants, my lord, are the grandson of Rajdev Mullah. He is also not aware in respect of the death of the grandfather. That is at paragraph B. And my paragraph 3 of the plaint has been dealt at page 25, paragraph 14. Only to the extent of the second part of paragraph 3 of the plaint has been denied, not the first part. Only thing
their claim is that they have become a lawful tenant.
Well, that will be decided in the suit.
Sir, that is because changing from 98 to 2001 has some significance, whether it's after the amendment of the Premises Tenancy Act or prior to that. So if it is prior to 1997 Act, which came into force sometimes in, I think, July of 2001, you have kept it in December.
Manad, I appreciate everything, Manad.
This cannot be.
Manad, let me
This
try
is
my luck.
withdrawing. No, Mr. Mukherjee, this is withdrawing admission, not trying your luck.
Manad,
Not trying your luck.
I'm not withdrawing admission. They have also not controversial.
Maybe.
They have not denied.
Maybe.
Manad, I should get a chance as a landlord, my lord.
No, no.
Manad,
Maybe.
ultimately the suit will be decided, my lord. But only one, Manad, I just want to try my luck. Manad, they have not denied. Otherwise, I wouldn't have come. Manad, in both paragraphs, they have not denied.
Maybe.
Being a landlord, my lord, I should get one chance to deny myself. Now, otherwise, the whole property will go. Whole property will go. It is not being denied. When I have gone through the written statement, it is not being denied. And my kindly come to my
Now, in the evidence, you have also stated that it is died in 1998.
But I have stated, but we kindly come to page 56. That is my application.
Reaffirmed cross-examination also. Cross-examination you have reaffirmed on oath. So it's withdrawing your admission, Mr. Mukherjee.
Kindly come to page 54, my lord. My lord, kindly come to page 54. Reason which I have given. Where he used to stay and where he has expired. Being the defendant being the grandson, my lord.
But this changing of date cannot be permitted.
I just need
at this stage.
My lord, the whole property will go, my lord. Whole property. They have not.
Mr. Mukherjee, they cannot become the owner. They are claiming tenancy right. So you have filed a suit for eviction of a trespasser. You have filed a suit for eviction of a trespasser. Their claim is that of a tenancy. So their predecessor was a tenant. Their predecessor was a tenant. So your trespasser is on the ground of 2G of the West Bengal Premises Tenancy Act, which you are trying to withdraw by changing this year.
The father has also expired, my lord, subsequent to 2001.
Maybe Mr. Mukherjee, subsequent to 2001, if they have inherited, that's the latest decision, Ramesh Mitra or Rajesh Mitra. So you are trying to.
Malad, I'm not trying to draw any inference. Malad, only thing.
Yes,
Malad,
because
it is.
it's changing the date has an impact there.
Malad,
Mr. Mukherjee, changing the date will have an impact there. It's an admission, you cannot withdraw that. Whatever it is there, you prove your case. Because your case of trespasser lies in that.
One chance, Malad, kindly Malad, give me one chance in this revision if I can satisfy your lordship in respect of.
Mr. What you will satisfy is withdrawal of admission.
Malad, they have not denied in the written statement.
Changing the date
denied.
will cause prejudice to the other side. Those amendments cannot be allowed.
Malad, let them come. Let them come here.
2022 16 SCC.
Malad, I know, Malad. Malad, let them come, Malad.
You know this,
Malad, let them
this
come,
application.
Malad. Kindly, Malad. Malad, they have not
this
decided.
case.
Malad, they have
Not in this case. This application under Article.
Malad, kindly not.
This application under Article 2.
Kindly not. Let them come.
This
Let me have a
application
My lord, a senior is online, my lord.
Yes.
Lordship, I'm for the petitioner, your Lordship.
Yes.
Lordship, my order 6, rule 16 application.
Yes.
My order 6, rule 16 application for striking out certain portion of of pleading was rejected by the impugned order, your Lordship.
Yes.
Your Lordship, kindly straight away, kindly come to page 18. I've annexed the copy of the plain, dear Lordship. Page 18, para 6, your Lordship. I'm the defendant number 1 in the suit. Now kindly see, Lordship kindly sees how I have been described. I've been described as a gunda. The plaintiff opposite party has described me in such a manner, your Lordship. Now these pleadings are absolutely irrelevant, not at all connected with the relief sought, your Lordship. The suit is for declaration and permanent injunction, your Lordship. Your Lordship would find the relief sought in the plaint at page 20 and 21, your Lordship. Impugned order, your Lordship. Is your Lordship looking for impugned order? Lordship, impugned order is
Mr. Chatterjee, you are opposing. এটা কত নম্বর item?
Item number 9, your Lordship.
Oh, আচ্ছা,
Appearing for the first time, your Lordship.
Mr. Chatterjee, you are opposing this application?
No, my lord. Next matter.
কি হলো? There is substance in the contention of the learned advocate for the petitioner that the second line in paragraph 16 of the plaint may be unnecessary, scandalous, frivolous, or vexatious. First up, petitioner is directed to serve a copy of this application by registered speed post with acknowledgement due and file an affidavit of service on the next date. First up, list this matter under the heading motion in the monthly list of December 2025. Petitioner is directed to serve a copy of বলেছি তো।
Lordship, in the meantime, the proceeding before the learned court below may kindly be stayed, your Lordship.
No stay. Yes, call the next matter.
Item number 10, Lordship, I beg to appeal for the petition. Your Lordship, the learned advocate on record is presently out of town. Your Lordship, kindly keeps it.
Learned advocate on record
is currently out of town. There are some personal difficulties. For this reason, he has.
You are for the.
I'm for the opposite party. I'm led by Mr. Chatterjee. But the he's out of town, but he's made a very frivolous application. Milord, this matter has been.
Mr. Chatterjee, you are out of court.
I'm inside court, Milord. Moment I'm in on the video, Milord. I'm inside court.
No, not physically.
Not in India.
Not physically.
Possibly not in India.
I am very much in India for a very long time.
November.
Mr. Chatterjee, what do you say?
Well, my learned friend is not there, but kindly makes it clear the pendency will not prevent the execution from going on.
It's always there.
Their application is that this cannot be heard out by the normal code. It has to be heard out by the commercial code. This has been decided in this matter.
It has been decided.
It has been decided in this matter, and we have or if your lordship wants, we can produce them in the earlier and on the later date. But showing the pendency of this revision application, the execution will be state. That should not happen, in my respectful submission.
That is the law, Mr. Chatterjee. Pendency of a mere pendency of a civil revision application does not operate as a stay.
Absolutely.
Make those submissions before the executing court. Why do you need an observation from this court?
The problem is,
Mr. Chatterjee, for that you are there.
I am there. Your lordship is there. If my learned friend comes back on Monday,
Monday,
I'm making it not today then.
Not today, I don't know, because I was told your lordship is going to the circuit.
Yes.
I don't know whether that's correct or not. And then after that, your lordship is going next week,
Yes.
Yes.
Then kindly keeps it on Monday,
Monday.
Anything, Mr. Chatterjee, if it is not today, it will remain in the list.
Kindly next Friday, if your lordship keeps it, because Monday it would be impossible for
Monday also, please try to make an alternative arrangement. Mr. Chatterjee is opposing. Or I shall make that clear that pendency of the civil revision application shall not operate as a stay. That is all he wants. Let it be kept pending. Let the execution go on. That cannot happen. One day, yes, he has admitted, and today is the only.
Today is a buffer day. I can understand his problem.
Buffer day, only one day. But if you take 1 week, that might be a problem, because
next Thursday, at least, your lordship, because before Thursday, it would not be possible for me.
May I know my learned friend who's appearing? Right.
Who is appearing?
I have to get instructions from the learned advocate on record.
Who is the learned advocate on record?
Amar Singh is the learned advocate on record.
Unless you get the instruction, how could you appear? Hey, you have not received instructions from the learned advocate on record. You are appearing in this matter. You are saying you are not.
Yes, your lordship. I don't know who's the learned counsel leading me as of.
And Kali sees the name of the client. It's Mehak A. Punjab.
Record করে দিন on the prayer of the learned advocate for the লিখুন the learned advocate appearing for the petitioner prays for an accommodation footstep such submission and such prayer is vehemently opposed by strategy.
I don't oppose a prayer for adjournment. It's
কেটে দিয়ে লিখুন Mr. Chatterjee, learned senior advocate, appears for the opposite party. For the ends of justice, the hearing of the civil division application stands adjourned for this day.
Grateful.
Yes, next.
My lord.
Yes, call the next matter.
My lord, I am for the petitioners.
You are for the petitioner, yes.
Yes, my lord.
The Haldar, you are for the opposite party.
I am for the opposite party.
My lord,
This is come on this side. এগুলো রাখেননি উঠে দিয়েছেন নাকি?
My lord, in this case, mother of the opposite party filed a suit for declaration and recovery of possession against these petitions.
Mother of the opposite party filed a suit for recovery of possession.
Declaration and recovery of possessions. But in the yes, my lord. But but no notice has been, statutory notice has been served upon us. For this, we also appealed before the learned court for staying of this ex parte order. But this rejection was
the order.
Yes, my lord.
There's an ex parte degree.
Yes, my lord.
Yes. Then what happened?
Then this application was rejected, my lord. So no statutory notice has been served upon us, opposite party number 2 till date. And in the meantime, my lord, their execution proceeding has been going on. So in this situation, my lord, I appear before you, my lord, for stay may be given.
Yes, Mr. Aldar.
But this is a suit for eviction, my lord.
Please use the microphone.
This is a suit for my lord eviction. Opposite trespasser. My lord, suit, my lord, originally the mother-in-law of the present petitioner was
An ex parte decree.
ex parte decree. I'm coming.
Order 9 Rule 13. What happened to the Order 9 Rule 13?
Order 9 Rule 13 dismissed. This is second round of Order 9 Rule 13. One or after passing of ex parte degree, the pro forma defendant, the son of the original tenant, he filed an application under section 151 for recalling of the ex parte degree. That has been rejected. Thereafter, he prepared a miscellaneous appeal. That has been dismissed. Now, my lord, after that, he comes up with an application under Order 9 Rule 13.
The original tenant now comes up.
No. He is the, my lord, the son-in-law of the original tenant.
Son-in-law of the original tenant.
The present petitioner herein. The son of the original tenant took out an application for recalling of the ex parte decree. That has been rejected. He preferred a civil division application. That has been rejected. After that, my lord, the son-in-law of the original tenant took out an application under Order 9 to 13. That has been rejected. Preferred a miscellaneous appeal. My lord, this is, I am telling my lord the date. This is very vital, my lord. My lord, suit was, my lord, decreed ex parte on August 2014.
Suit has been dismissed on?
Suit has been decreed.
Yes, on
28 August 2014.
Yes.
My lord, Order 9 Rule 13 filed, my lord, in 2016.
Yes.
Now, my lord, Order
9 Rule 13 by him.
By this person.
Yes.
This Order 9 Rule 13, my lord, has been dismissed on, my lord, 18 March 2023.
Yes.
He prepared a miscellaneous appeal in 2023.
Yes.
Now, my lord, by this time, since, my lord, 2010 till 2025, he did not, my lord, bother to file an application for stay of the execution case. He allowed my execution case to be proceeded with. Now, my lord, my application for police has been allowed and I deposited the police cost. After that, my lord, he took out an application for stay of the execution case. Even, my lord, during pendency of the miscellaneous appeal in 2023, he did not bother to file application for stay. As soon as, my lord, I filed.
What is this suit property?
Suit property, my lord, about 1,000 square feet. My lord, 2 bedrooms.
About 1,000 square feet.
My lord.
Where?
My lord, Paikpara.
Paikpara. What was the rent?
My lord, I have a copy of a legal license of the same vicinity, my lord. My lord, it speaks, my lord, 13,500 is the, my lord, rental value.
13,500. Rental value of 1,000 square feet.
950 square feet.
950 square feet.
Similar accommodation.
All right. Yes.
My lord,
no, 15,000 from 2014 deposit. I will stay for a limited period. Direct the miscellaneous appeal to be decided. Deposit within 15 days.
Yes.
You will deposit.
Well, the amount will, my lord, I take
50,000 per month from 2014 till this date.
That is not possible. Not possible, my lord.
Then
My lord, at
it's
least,
better you find an alternative accommodation.
my lord, at least notice for serving of the notice, let them come, my lord.
They have come. Prior to your serving notice, they have come.
My lord, 15,000, but I can take instructions in this regard, my lord. But
No instructions. This application under
will actually look at the impugned order. Complete non-application of mine in an order 9 rule 13. There is a section 5. Without even condonation of the section 5, without even considering it, the impugned order has been passed. The Lordship kindly takes the impugned order. Impugned order is the order 9 rule 13 has been admitted and section 5 has been kept in abeyance.
What is the date of the impugned order?
My lord, it's 4th of September 2025. Your Lordship will find it at page 96 also. I have annexed it. Lord will kindly see her third paragraph on the point of admission. Heard considered let the instant miss case be admitted. Fix 26/11 at 11 a.m. for filing in affidavit in opposition of the OP against the application under section 5 of the Limitation Act. But without considering this
Substance in the submission.
grateful.
Yes.
Number 13. I beg to appear on behalf of the petitioner plaintiff. The suit was filed for eviction in the year 2016 before the Sialda court, learned Sialda court, and thereafter the suit was transferred to the Vidhannagar court. And since then,
What is the impugned order?
Impugned order as a whole. Because of that, since 2016, now 2025, on the last occasion, the defendant appeared.
Expeditious hearing you want?
Only expeditious.
Of 7172 disposed of?
No, on the last occasion they filed.
On the last occasion they have filed. Have you filed your written objection?
No, on the last occasion, that is 8 September 2025.
So November 26 November is the date fixed for hearing.
Yes.
You file your written objection in the meantime.
Well, written objection I will file, but your Lordship kindly direct disposed of the matter as because my client is 86 years old. And he is the only director. His wife is also director.
16, what you are doing?
My lord, this 7172 application not at all maintainable because of they appeared in the year 2018. They received summons 15/11/2018. And practically there is no provision of, in the provision of law, there is no scope.
This application
Item number 14.
I'm for the petition, my lord, item number 14. This is the revisional
Opposite party, my
For the opposite party,
This is the revision application, my lord, for challenging the order dated 12th August 2025, passed by the learned district judge, Paschim Medinipur, by dismiss the Mish appeal on the ground of 84 delays, my lord. Kindly see the order which I have included here in the last one, my lord.
yes, what is the ground for delay?
My lord, the petitioner has come to know about the order of the 16th January 2024 on 6th April 2024, my lord. And thereafter, without making any delay, they have applied and certified copy of the said order on 10th April 2024. But in the month of July, he has obtained the certified copy and without making any delay, filed the miss appeal, challenging the order dated 16th January 2024. And on 12th August 20,
Miscellaneous appeal is arising from which order?
16th January.
Nature of the order. What is the nature of the order?
The learned civil junior division first court. Now the ad interim prayer of the visit for to hear of the plaintiff of the suit.
So the temporary injunction application is pending.
Yes, madam.
I am directing the temporary injunction application to be disposed of. What we will get? Section 5, miscellaneous appeal, civil division. I am directing the temporary injunction application to be heard out.
My lord, my submission, lord, kindly
file your written objection to the temporary injunction application.
Yes, my lord, I have filed. Kindly see
What is the date fixed for hearing of the temporary injunction application?
My lord, kindly see page. Page my lord 17 of 16 January 2024 the order, my lord, kindly see.
Page
17.
Yes.
17, my lord.
Yes.
The petition for temporary injunction.
Temporary injunction disposed of. We have said ad interim order. We have said.
That's why, my lord, this is Miss Appeal has filed, my lord. But 84 days delays they are, my lord, so on the ground that it dismissed.
Where is your application under section 5?
My lord, this is page 21. Page 21, my lord. Yeah.
Yes, what do you say?
My lord, copy notes have actually
Copy has not been served. Serve him a copy.
Lords.
I'm grateful. I'm grateful.
Not today, next.
Item number 16.
16, I appear for the petitioner defendant. Now, two orders have been challenged. Now, one is the order dated 16th of November 2024, where an application under 151 for recalling of the rejection of 7.3 was allowed, my lord, ex parte, my lord, without affording an opportunity.
16th of November
2024. 151 of CBSE at the behest of the plaintiff was allowed.
What was the 151 for?
151 for recalling of an rejection of 7.3.
Recalling, rejection of
7.3 in the year 2022. Thereafter, I filed an application under 151 of CBC for recalling of that order. Inter alia, stating that I have not been given an opportunity of being heard. What happens is that on 16th of November, when the matter was fixed for hearing, the plaintiff take out the file and move the matter before the learned judge in charge without giving an notice to the defendant, and the learned judge in charge allowed the said application. I have highlighted the entire fact and filed an application under 151 of CBC. The learned court, while considering my application under 151 of CBC, clearly stated that I am not vigilant.
No, 7.3 has been directed to be heard. How are you prejudiced? Make all points in the 7.3 application.
There were all observations have been made, while making the recalling application.
Where? I will direct that the 7.3 application will be heard without being swayed by any of the observations made in the Ashun. This application under Article 220.
So, Mr. Lord, I am appealing with the preemptive petitioner.
Preemptive. What is the point, Mr. Rai?
Enter share. What happened, my lord? It will appear
Doctor bench.
That is why precisely, my lord, I prayed before the court below. It is before the court below that unless until that is the issue involved. So before that, let the matter.
What remains in the entire share, Mr. Rai, it has been decided.
That is, once if your lordship decided, then everything will go. Otherwise, what is going on with the court below, my lord? Now there is a dual. One side is coming and saying this is pending. Someone is saying it is material. My lord has the access over the.
How can I decide that it's pending before the larger?
Larger is whether my lord, no, it is up. And whatever Mr. Justice Sen, Justice Kapoor, and Justice Bhattacharjee was there. Subhash now so basically
not yet been decided.
Not been the last order I have annexed also. Now the court below I have filed an application. Let them because that is the main issue involved in this revision application.
Necessarily, you have made complications.
Oh,
share, Mr.
That is
the language is very clear. Language of section 8 is clear. Unnecessarily, you have complicated.
Peace and that is the precisely. I am also against it can be done restrict to fact whether it's the entire share or the plot of land. If you logically consider it that way, entire plot of land. If you logically everything if a riot to be termed to be a unit, single unit, one can consider it that way, single unit. Co-share of a riot. So if the riot transfer the single unit transfer is entire share, that includes the entire plot of land has been transferred. If a co-sharer of a riot, then one not restrictive fact whether he transfers his entire share, that must be a portion of the land. That is, I filed an application for the court below. Let it be decided because that has been turned down. I am drawing your attention only to the portion which, in my objection, which I have stated. If you logically turn to page.
This application under article, now, Mr. Rai Lanet
Item number 19.
19, my lord, I am appearing on behalf of the plaintiff petitioner, my lord. This revisional application is, my lord, against the rejection of an order passed in an application for police help. My lord, suit for partition and injunction. The plaintiff filed the suit along with an application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure. The order of injunction was passed, my lord, by the learned court below. Thereafter, the petitioner filed an application for receiver. Receiver was appointed. My lord, the receiver, when the receiver went to the suit for party, my lord, the defendant opposite parties, my lord, assaulted the receiver as well as the plaintiff. Consequently, the plaintiff filed an application for police help. Initially, my lord, that police help was rejected on the ground that the defendant and the plaintiff both undertake to amicably, my lord, the fishing the pond, my lord, but subsequently they have not done. Again, the plaintiff petitioner, my lord, filed an application for police help, my lord, which is annexure, which is page, my lord, 35.
35, yes.
35. That application was rejected by the impugned order, my lord. Challenging the same, my lord, I have come before your lordship, my lord.
Where is the order appointing the receiver?
Receiver, my lord, I am inviting your lordship, kindly come to page, my lord, 32. Record is put up today by way of put up petition filed by the plaintiff. Plaintiff have filed a petition under Order 40 Rule 1 of CPC praying for appointment of receiver as per stated in the petition. Copy served. Let the petition be taken up for hearing. Plaintiff have filed the instant petition.
So if the receiver faces any difficulties, the receiver was appointed who is to cultivate and who is to catch the fish. So if the receiver feels any disturbances, the receiver will approach the court.
My lord, they have not done, my lord. Consequently, the my lord,
no right to catch the fish.
No, my lord, I have no right, but my lord, but my lord, the receiver and the plaintiff, my lord, kindly come to the page 34, my lord, order dated 27.
Nothing is on record from the receiver to show that the receiver was instructed by anyone.
My lord, receiver was directed to file a report, but still now receiver have not taken
against the receiver.
My lord, no.
You take steps against the receiver. For that, police help.
My lord, kindly come to order number 27 for a moment, my lord.
Yes, 27.
My lord, page 34.
Yes.
Order page 31. One learned advocate for the plaintiff has filed one petition praying for police help. Both the learned advocate and defendant are present and verbally submit that they will jointly went to the local and catch the fishes in presence of receiver during summer vacation. As such, put up petition and police help petition stands rejected. My lord, both the parties, my lord, jointly submits before the learned court. My lord,
no, but that was your petition. But the order appointing the receiver is at page 32.
Yes, my lord.
He was appointed for fishing the pond and for selling them for deposit. So you have no right.
My lord,
you have no right.
I have no right, but my lord, to carry out the order of status quo, my lord, passed by the
status quo does not say that you are in possession.
My lord, kindly consider, my lord, other
you are not in possession. The receiver was directed.
Receiver has not taken. Receiver was directed to file a report.
Sir, if the receiver has not taken his steps, take steps in accordance with law.
My lord,
take steps in accordance with
without police help, my lord, receiver has.
The receiver has no. That's not the statement of the receiver.
My lord,
that's not the statement of the receiver.
I have stated in my petition for police help.
If the receiver is not taking steps, you apply accordingly. Ashun, this application under Article 227 of the At a sentence, it is however made clear that this order shall. Yes, Mr. Rai.
Initially, suit for partition was filed. Suit was dismissed. Against the appeal was preferred. Appeal decreed.
Partition suit dismissed.
Partition suit dismissed against the appeal preferred. Appeal decreed in plenary form.
Appeal decreed.
Decreed. Subsequently, it appears that the applicants referred to lordship applicants petitioners. Their predecessor was made party, but after dismissal of the suit, appeal was preferred. During this period, he died. Without substitution, proceedings continue and suit was decreed.
So decree against a dead person.
Dead person. Then a suit.
So your predecessor was the defendant.
Defendant. I filed because subsequently we have also filed a suit for partition encompasses that those properties, including the other parties. They came and disclosed for the first time that this suit was.
So you have also filed subsequently
Yes,
a suit for partition.
In that suit, they appeared and said that already a suit for partition has been filed and it was decreed in appeal. I filed an application for stay along till the disposal of this earlier suit.
Stay because final degree.
Final degree proceedings is pending. I came before this honorable court. Now, my lord, I am drawing lordship petition. So for
that stay was rejected.
Rejected. At that point of time, I came before this honorable court.
Yes. Then what happened?
This honorable court, my lord, can turn to the order, page 58. Can you turn to page 59? Said, I am of the prima facie view. My lord, got it.
Page?
It starts on page 58.
Yes.
I'm drawing lordship attention to page 59.
Yes, I am of the prima facie view.
That once the preliminary degree has been passed by the lower appellate court and no challenge having been thrown thereto, ascertaining the shares of the petitioner would necessitate ripping open the preliminary degree passed by the lower appellate court by the trial court. That, to my mind, would not be permissible. In any event, the appeal having been allowed, the remedy prima facie lies in praying for recalling of the order passed by the lower appellate court, on the basis of which this.
Now, on the basis of this is the earlier partition suit.
Yes. In the earlier partition, I filed an application for addition of party and also a stay. The court is of the opinion that was rejected. I came before this honorable court. This honorable court is of the opinion, unless until you pray for recalling of the judgment until it is immaterial whether you have added as a party in the final degree proceedings because your share has not been declared. So, direction was given.
No, you are not added.
Yes.
You are added.
No, I am not added.
Yes.
That is why.
Who filed this civil division application?
This petitioners, your lordship filed.
No, what was the impugned order in that civil division application?
My addition of party was rejected and stay was also subsequently rejected. The court is of the opinion that unless until that degree is recalled, the appeals court degree is recalled, you are not entitled to get any benefit in the execution procedures or the final degree procedures.
What happened to this civil division application?
That was disposed of. After that, I could not dispose of the revision application. I will find.
I could have disposed of the revision application, granting liberty
to the petitioner to take appropriate steps. The petitioner submits
for filing an application.
Review or recall.
Recalling,
so time was granted. Why?
But you have not paid for recalling of that. You have filed a separate suit.
No. Here, my lord, after pursuant to this order, I filed an application for recalling.
No, you said you have filed a separate suit for.
In that suit, we came to know that another suit had already been decreed by the appellate court. Initially, a suit was filed for partition, where my predecessor was implicated as a party.
That suit was dismissed.
Dismissed against that appeal preferred during in the intervening period.
Preliminary decree was passed.
Degree was passed by the appellate court.
Yes, degree was passed by the appellate court, and your predecessor was not substituted.
Not substituted. Now, my lord, we have also filed a suit.
Thereafter, you filed a suit
for partition.
They came and
disclosed about the proceedings of the present party.
Then you went to file an application for addition of party
and stay
in the earlier title appeal,
and for stay.
Yes,
that was rejected.
Yes,
I came before this court.
Yes.
This court is of the opinion that unless their degree is recalled,
yes,
you have no remedy lies so far the substance is concerned.
Then what do you do?
Yes, that then liberty was granted to, then I filed an application for recalling. That is what.
Oh, you file an application for recalling.
Yes.
Yes. Then what
It has
happened?
been rejected
By this impugned order.
by this impugned order. That is why precisely when I turn to page 61.
Now, Mr. Rai, since you have filed a suit for partition, so you admit the unity of title.
Yes.
So now, the preliminary decree in the earlier suit, where your predecessor was a party,
that was
there only the plaintiff's share was declared. Are you disputing the plaintiff's share here?
So for that portion, my lord, I do not have any.
No. What is your claim here?
In
or in your suit for
yes,
partition?
my lord, I will also annex that. If your lordship can
Yeah, have you disputed the plaintiff's share?
Yes. To some extent, dispute is there.
What is according to you their share? What is the dispute? What is the share declared in that suit, and what is the share according to you in your suit?
If your lordship can you turn to page 35 once.
Mr. Raj, 70 Calcutta has been diluted.
Diluted. In subsequent judgment where it is said, order to rule 10 capital is a mandatory nature. You cannot stand in the side of the face and allow the process to continue. And
that's the recent decision.
Yes. I'm conscious
by
of
the
the
same presiding judge. Pass this order. I think.
Yes.
So
that is here.
The decree will not be a nullity.
Not a nullity. Whether my party
not
have
be a
entitled to
nullity.
participate or not.
Yes.
If that is so, then in either way, the court is of
Since
the.
your predecessor was a party, maybe that the decree is not a nullity, but either your predecessors or your shares have to be declared.
Not only that, at the final degree proceedings, I have a say to contest. Because the present position is required to be considered for the purpose of demarcation.
That is, if you challenge the final decree, you can.
But if I have not
challenge the preliminary decree, you cannot. You are stopped from challenging in the final decree the correctness of the.
Yes, that is unless I made party, then one of the final degree can be challenged by me. But against my predecessor, the suit was decreed.
The title appeal was filed by the plaintiffs in that suit.
Suit was dismissed, particular suit. And same was dismissed for default, subsequently restored title appeal. Now, there are two things.
But Mr. Rai, you had a right to file a second appeal against this.
But this is a recalling in that.
Leave to prefer an appeal. Though you are not a party, you can very well challenge the that preliminary decree in a second appeal.
Yes, if I am not a party, then why not
not a party?
Leave to prefer a second appeal on the ground, why not? I have not been made party.
Yes, and your rights have been affected because your shares either have not been declared or wrongly declared.
I have not done that. I am on the basis of the fact that a party.
What is the reason? Please show me.
The reason is the appeal list.
Appeal?
You have to prepare an appeal. That is precisely
appeal, right. Second appeal, Mr. Rai. Right.
Then, my lord, it is contrary to the direction passed by the.
Mr. Rai, that is the liberty.
Not the interlocutory. That is not the interlocutory order. That was the decision taken. Allow me to participate, keeping the proceedings pending to grant stay. That whether I can. In the meantime, I can challenge it or not. That is why subsequently I have to withdraw the same by showing that yes, I have already filed an application for recalling. Am I clear to your lordship? If that be so, then that is
how that has been dealt with by the the order of the High Court. How that has been dealt with. Show me that.
If your lordship, I turn to internal page 2, last paragraph. Prior to
internal page 2.
Internal page 2 of the impugned order, last paragraph.
Yes.
Here is no direction from the my lord prior to giving focus on
internal page 2, last paragraph, prior to giving.
Yes. Once the appellate court has disposed of the appeal or contest, how the appeal was in proceedings in form of as if it were not disposed of on contest. Here, there is no direction of the Honorable High Court to rehear the appeal afresh, or there is no order of the High Court to keep sustained the appeal by considering it on read not disposed of on contest. The learned counsel who have been proceeding the appeal, in spite of the appeal not being disposed on the earlier on contest, and without preparing any second appeal before this High Court, he has withdrawn he has drawn the attention of the court to the order of the Honorable High Court passed in such and such. Then enter order has been quoted, my lord. Next page, page 4, bottom.
Where is the provision for recalling of a decree, Mr. Rai? Setting aside an ex parte decree is one thing. Where is the provision for recalling a decree? It's not an ex parte decree. Where is the provision for
The
recalling?
degree is subject matter.
You are aggrieved. Even if you are not a party, you have to prefer a second appeal.
In other way, my lord,
if the liberty was given, liberty does not
confer any
right upon you.
What is
because
statute?
statute says something, so you cannot be bypassed by a
Yes, but
liberty
the
being
statute,
given by a
well, that all the that is a
because Mr.
even if my lord today the what is second appeal? If I
second appeal that thing, because if you
that
take
is substitute
70
for
Calcutta is also the same thing.
Calcutta, my lord, whether my lord, that will
There
apply.
is the question of Mr. Rai, there is no abatement.
No amendment. So,
but when you can file a fresh suit also.
oh my lord, after pre-decree, my lord, that is
till a preliminary decree is passed. But once a preliminary decree has passed, then the question, yes.
So subsequent suit.
So now you can prefer a second appeal. Second appeal, there you can say there the decree can be set aside. But where is when a decree is passed? Where is the provision for recalling of that decree?
I may come back, my lord. I require some time because this point initially, my lord, though I have
liberty, I appreciate.
But my argument I have been sketched, my lord, on the basis of the liberty has been granted by the High Court. Whether the court can ignore that.
Because if a decree is passed, not an ex parte decree.
Yes, on contest.
On contest. So either for recalling.
Then my lord, it should be ex parte against the person on contest, even the remaining defendant. Ex parte is over the rest.
And please bring that recent decision.
Yes.
Supreme Court also where 70 Calcutta was considered and diluted.
Yes. Previously, my lord, order 22 rule 10 capital A was not mandatory.
That will be against you then.
Precisely, my lord.
So that Supreme Court judgment will be against you.
Yes. But on the basis of which I want to argue, my lord, it is a degree.
Then perhaps second appeal would have been the rightful remedy because person affected.
Then my lord, can you consider this degree has been passed against the expertise over me is concerned. My predecessor is concerned.
Mr. No. That's the logic of 70 Calcutta. Because why the decree passed against a dead person is a nullity because the heirs have been deprived of an opportunity to contest.
So I mean, it is an expertise degree against me.
70 Calcutta.
So this is an expertise over me is concerned. So I have a right to recall that degree over me is concerned against me. Am I clear to you, Lord Shriman?
That I've followed, but when the statute says when a decree is
remedy is on the statute itself, if the degree has been passed on contest against some of the defendants are ex parte.
Then order 9 rule 30.
Yes, so it can be termed to an order 9 rule 30 also. Then rejected order 9 rule 13 in a title appeal is also reversible order.
No, that is
in either way. Well,
according to you, it is to be considered as an application under order 9.
If that is so, for me is concerned, it is ex parte degree.
So,
So, my me is concerned, it is ex parte degree.
That is the logic of 70 Calcutta.
So,
Because why the decree passed against a dead person is a nullity because the heirs have been deprived of an opportunity to contest.
That argument I can advance before your lordship in either way. But what is followed by my lordship, it requires some consideration to what extent a degree can be recalled on the basis of contested degree can be recalled. But when a person participates in that degree, whether he can recall or not. If a person is not participating in the proceedings,
When did your predecessor die?
when the title appeal was dismissed for default.
Title appeal was also dismissed for default.
Subsequently restored.
At what stage it started?
Died 1991.
Yes. No, I'm
Suit
not
was dismissed.
I'm not on the date. I'm the stage when it was dismissed for default.
Suit. Initially,
title appeal dismissed for default.
Suit was dismissed on 2000.
Suit was dismissed on merit.
Merit. During the
Title
pendency
appeal.
of the suit, died.
During the pendency of the suit died.
Died. 1991.
So in the title appeal, the dead person was impleaded as the party.
The party had proceeded with. So in a partisan suit, I could have as a suit was dismissed, so there is no amendment in that sense.
Yes.
In that sense. But whether my application can be rejected on the ground that I did not prevent an appeal.
Then if we go by 70 Calcutta,
Then
he has to be substituted in the suit itself.
Suit court. But 70 Calcutta, what is followed by your lordship? I bow down to your lordship.
Now it
That,
has been done.
that 22. Previously, it is not mandatory but directed in nature order 22 rule 10 capital A. But subsequently, by this judgment, it has said it is mandatory. It is your duty casted upon you to inform the court and also the others that this is a person died.
And after something has happened,
Then
you
you
cannot come and say decree is nullity.
That you cannot say. So these are the two things my lord has to consider in that way. If it can be termed to be an ordinary rule 13 application for ordinary rule 13, then my lord has the jurisdiction because it is an appeal revisable under the law.
Mr. Rai, learned advocate, Mr.
21, my lord, I am for the petition.
ফাইলটা দিন একটু কারেকশনটা করুন।
My lord, in a suit for declaration of title and recovery of possession filed by the opposite parties, my lord, the plaintiff
Declaration of title and permanent injunction.
for the and for recovery of possession.
Recovery of possession, yes.
My lord, the present defendant, he has filed written statement stating that the suit has been undervalued. Because there was an agreement in between the parties by virtues of which I have been taking possessions of the property and the suit property was agreed to be sold at a price of rupees 10 lakh. But he has now, my lord, valued the suit at a price 1 lakh. My lord, an application was filed for inquiring for determination of the valuation under section 11 of the Court Fees Act.
Yes.
And my lord, an application was also filed, my lord, for
At the argument stage, you file that application.
my lord, that application was filed, my lord, the court allowed that such applications, my application has been allowed, but at the same time, my lord, fixed the argument.
Your application has been allowed?
Yes. Kindly look into the order, my lord, itself. In the first portion that the petition dated.
We heard along with the argument of the suit, it has not been allowed.
The petition for shifting back the record from peremptory hearing board is hereby considered and allowed. Ordering portions with cost of rupees 2,000.
Yes, that is shifting back. Then it has been said that this application, considering the I am now belated stage, challenging the valuation already fixed for argument, let the petition challenging be heard along with the argument of the suit. How are you prejudiced?
So far as
If the what is your stand? The suit is pending where? Senior division.
Senior
so it cannot house the jurisdiction of the civil judge senior
So
division.
far as that is concerned, my lord, so far as the
Jurisdiction part is not affected. So if the court ultimately finds, you'll only direct the plaintiff to deposit the balance court fee, Mr. Mitro. Nothing will be. Asun. This application under Article 220.
Well, this is well, expedient disposal of the partition suit, well, suit of well, 2017. Well, status order,
The stage of the suit.
well, status order was passed in order 39 rule 1 and 2 in the year 2017. Well, that well, injunction application was not disposed of as yet. Well,
Injunction application is still pending.
yes, my lord.
This application under Article 227.
Well, interim order.
Extension.
Yes, my lord.
Where is your,
Well,
yes, Mr. Bhattacharya has come.
Yes.
File টা বার করেছেন?
My lord,
Yes.
Now it has, this is the first day cannot be relocated.
my lord, we have already made an application for vacating of the
Extension of
interim order.
interim order. Under the heading extension of interim order, Monday.
Yes.
May I pay one?
Also, well, there is substitution application.
Substitution application, if it is pending unless that is disposed of, how can the interim order be extended?
Yes, my lord. Well,
If it is within time, take steps.
Well, substitution application, my lord, on the last occasion, lordship, will see the order.
Extension of interim order heading এ রেখে দিন তারপর যা। Monday.
My lord,
Monday, but we have also made an application for vacating of the interim order, my lord. That is pending. Because this is an order, interim order is, my lord, from the municipal building, my lord, the
218 of the
218, my lord, the
18.3.
traffic order.
18.3.
Now, my lord, the interim order obtained by suppressing a fact that a coordinate bench already give a direction, my lord, to implement the order of demolition. That was suppressed.
No, my lord, thereafter,
One thing, the statutory right of appeal. So can you take away a statutory right of appeal
The appeal is
by directly?
My lord, the appellate court, my lord, confirmed the order of demolition. Thereafter, I came before this honorable court for implementation of the order of demolition. Now, my lord, that fact was suppressed. By suppressing that fact, they obtained the interim order.
Be it for extension of interim order, give your application vacating টাও একসঙ্গে রেখে দেবেন বুঝলেন? এক্সটেনশন অফ ইন্ট্রিম অর্ডারের হেডিং এ রেখে দিয়ে ওনার ওই ক্যানটা যেটা ভেকেটিং আছে আর কি সাবস্টিটিউশন
My lord, against the order, we have filed a my lord, appeal, my lord, before the division bench. And my lord, we have also filed a supplementary affidavit, my lord, before this, my lord, honorable court,
why
my
did
lord.
you suppress this
Not
fact?
stop, my lord.
You are saying you have suppressed these facts.
Because that is the reason you filed a supplementary. Thereafter, my lord, the order of the division bench. My lord, I filed a supplementary affidavit
You
thereafter.
have suppressed the fact, consequences will follow.
No, my lord.
If you have not suppressed, nothing will happen. Yes, call the list.
And my lord, my lord, order was passed in presence of them, my lord.
For judgment.
In view of the aforesaid discussion, this yes.
Supplementary list, item number 2.
Two and three.
CO 2194 of 2025 stands disposed of with the hope and trust that the learned trial judge shall make an endeavor to dispose of the suit as expeditiously as possible without being influenced by any of the observations made by the learned district judge in the impugned order as well as by this court in this order. There shall be, however, no order as to costs. This is CO 1687 of 2025. Accordingly, the order dated April 7, 2025, passed by the Learned Civil Judge Senior Division 10th Court at Alipur in ejectment suit number 47 of 2024 is set aside. The Learned Trial Judge is directed to fix a date for further cross-examination of PW1 by the petitioner and to make an endeavor to conclude the cross-examination of PW1 at the earliest. The learned trial judge is further requested to dispose of the ejectment suit number 47 of 2024 as expeditiously as possible without granting any unnecessary adjournments to either of the parties. CO 1687 of 2025 stands allowed with the aforesaid observations and directions. Yes, call the list.
Item number 22. Item number 23.
Yes, Mr. Jana.
Yeah, pay your lordship. Lord, the petitioner by your lordship is kindly see page number 37. Page number 37.
Number 30. What is the impugnation? Who are you?
Well, I'm going there. I'm going there. Kindly see page number 37. That is the application of the defendant, petition to my lordship under order 23 rule 3, section 151.
What? 23 rule 3.
Well, the fact of the case is our kindly see. The petitioner, before lordship, the defendant in the title petition to suit.
Give me a minute.
Well,
or a third party.
No,
you are a party in the suit.
I am the defendant. Only defendant.
Party in the suit.
My lord.
Yes. On what ground this application was filed?
Because factual, in all the plots is valid between the parties. The plaintiff is the elder brother and the petitioner is the younger. Well, the petition should filed by choosing a several plots of land, which are in my possession. But all the plots are not included. That's why in the written statement, page number 19, I have stated that all the plots are not included. That's why you kindly see the order, page number 31, order number 20. It is reflected that yes, you should have to include those plots of land which are reasonable between the parties. But that is not done. You should have to do so. Otherwise, it cannot be done. Adjudicated. That is page number 31. Can you see that?
Can a decree of a award of a Lok Adalat be challenged?
After filing that written statement, immediately thereafter, you
accepted that.
The petitioner.
You accepted that. So can an award passed by the Lok Adalat?
Yes, cannot.
Then
that's why
if it is cannot, then
kindly see, Lord. The petitioner of your lordship is not the literate person, only knowledge of signature.
There is a bar once decree has been passed by the national local
cannot be look into page number 37 below. And kindly come to page number 31, that is order number 20. After filing that written statement, that order that he has been defected, page number 31, order number 20.
What is the particulars of the fraud you have alleged? You have not given any specific particulars of the fraud. If you allege fraud, your allegation is of fraud.
Yes.
You have to give particulars in view of Order 6, Rule 4. Where is that specific particulars of the fraud given in this application? Mr. Jana knows particulars of fraud has been mentioned.
But I have stated in my application that
show me particulars of the fraud. How fraud was practiced?
I also stated in paragraph 5, my lord, can you see?
Paragraph 5 of what?
Of the of this application.
That I cannot look into.
And
show me from the application under Order 23, Rule 3. First of all, that is also not maintainable. You cannot apply under Order 23, Rule 3 because this is not a decree passed by a civil court. It is a decree passed by the National Lok Adalat. Decree passed by the National Lok Adalat. You cannot recall that. Cannot be recalled.
I have stated in the application that is practicing fraud. That is page number 37.
Saying that practicing fraud will not do. Please see Order 6, Rule 4. How fraud was practiced, you have to give specific particulars. One line by practicing fraud will not do.
But suppressing that fact that all the suppressing that fact that is procured by signature. And
that award, Mr. Jana, the award of the national. Do you have the Legal Service Authorities Act? Have you brought that? Have you checked up that? Without checking up, you have filed this. Cannot challenge that. Please check up that provision. Cannot challenge that. Your remedy lies elsewhere. Please advise your client accordingly.
But that is illegal in the sense that all the plots
Sir, this is not a decree. Order 22
This
is a decree passed by a civil court. It's not a decree passed by a civil court. National Lok Adalat.
Yes.
Under the Legal Service Authorities Act. There's a bar. You cannot challenge that. Under Order 23, Rule 3. After some argument.
As your lordship. As your lordship.
Please check up those provisions. And what is the remedy? Please see.
Then make it adjournment so that praying for adjournment for 1 week, Lord, I shall come back. Any day in the first week of November. Any day in the first week of November,
Any day in the first week of November. All right. After some argument.
In the meantime, may I have copy? Not necessary.
Unnecessary, don't serve copy. Please undertake those research work. Your remedy lies elsewhere.
Also, plaintiff petitioner hearing lawsuit. Plaintiff filed a money suit. It was.
You are the plaintiff.
Yes, lawsuit.
Yes. What is the impugned order?
Execution dismissed.
Execution dismissed. Why?
The money should have been done. Lawsuit. I came to lawsuit.
On compliance of the order.
The suit was filed and decree in the state of Uttar Pradesh. Thereafter, execution proceeding was transferred to the district judge Tamluk. Thereafter, it was transferred to the contract.
You have not deposited that cost.
Yes,
1,000.
Yes, lawsuit. I showing earlier order lawsuit. Lawsuit. I also challenging that order lawsuit. Why I am not depositing lawsuit? Lawsuit kindly come to order number 27th March 2025. Lawsuit.
Yes.
Lawsuit today the date is fixed for appearance and proper step by the decree holder. Decree holder file and hajira fresh vokalnama today, but not a single decree holder is found present in the courtroom. No appropriate step is taken by the decree holder for issuing the writ to execute the decree. The laches on the part of decree holder cannot be ignored by this court. The decree holder are accordingly so coach as to why the instant execution case shall not be dismissed for default on the part of decree holder themselves. Next date for
Rightly.
Have
you seen the newspaper reports? I think 5-6 days before.
No.
Too many execution cases are pending. Our Supreme Court has.
That judgment I lost you.
So relying on that judgment, this order has been.
Yes. That judgment was passed in the Uttar Pradesh. That was transferred. After came to know, no notice was served to the court from the court. After came to know, I appear on.
Have you not deposited that cost?
Lordship, kindly come to the next order, 5th April 2025. 5th April 2025.
Yes. Fifth April 2025, yes.
Today is date fixed for Sokoj. By the decree holder, ID dismissed. There is a file Hajira. Decree also file Sokoj reply supported by an affidavit. Has the learner advocate for the decree holder consider peruse the case record and Sokoj reply by the decree holder. The Sokoj reply, the decree holder being found bona fide.
Cost of rupees 2000.
2000.
Yes.
To the
Did you deposit this 2000?
yes, lordship, on the same day, I filed an application under order 221 rule 54, praying for amendment of the execution case. That was not reflected. I annexed the certified copy of this application also. Nothing was reflected regarding that application. Only next date lordship.
Sir, you are not taking steps. Again on 19th of June, you failed to take any steps.
Lordship,
Influence of read.
because of that, why not? Application under order 21 rule 54 without allowing lordship, without implemented the property which was to be attached. How can I deposit the issue the read? Without because of the suit property was the hotel of the Mandarmani.
Come after 2.
24 loss. Lordship, the decretal amount is decretal amount is 9,35,000 and 6% interest from the 2012. Lordship, kindly come to my original execution petition filed before the Raipur court. Lordship, page. It was page 41, relevant page 44, Lordship. Yes. List of movable property of the judgment debtor. Lordship, kindly see this property. 9 lakhs and 6% cannot be recovered from this property. Thereafter, Lordship, kindly come to the transfer order. Page, Lordship, 45. Relevant page, Lordship, 46, Lordship. Lordship, the main debtor are absent. The case is fixed for further proceeding. The decree holder has submitted an application under section 39 CPC. Hard on the application, the decree holder has submitted that the case is fixed for recovery from as the judgment debtor execution. The judgment debtor office is situated at the East Midnapur, West Bengal, which comes under the pecuniary jurisdiction of the district court East Midnapur, West Bengal, where the judgment debtor is residing and movable, immovable property assessed. So this execution case lawfully pleased to transfer the honorable district judge is Midnapur, West Bengal. Immovable property is situated under this contact court. Thereafter, Lordship,
By the
that was also same, but he had dismissed on the ground the decree holder was not present in person. Lordship, kindly come to the order 5th April 2025. Decree holder not come to the personally, so the execution is dismissed.
What are you doing? In all matters, the decree holder did not take any step.
This matter, decree holder is the bedridden. Decree holder execute the power of attorney. Power of holder giving the vocal number to the line advocate appear. But the court observing that the decree holder should be present personally. In the earlier order also, seen that none appear on the decree holder.
Showcase petition was also not filed. Showcase petition was also not filed.
Showcase was filed. That was withdrawn, Lordship. Lordship, kindly,
if it was withdrawn, amounts to non-filing.
Yes, same thing. Bound that the degree holder not affidavit the Showcase petition, so you should be withdrawn.
No. Where is that?
That was not reflected in your order, said Lordship. But
that file an application for review.
That was also already filed, Lordship.
Review application filed?
No, review application was not filed.
If you said that it has not been recorded, file an application for review. Later on, not press the same.
Yes, the court pressurized the land advocate to withdraw this application. Otherwise, how the...
Where have you stated that this court forced the court to not...
Yes, that was possible. That was I stated in my application.
So you file an application for review there. If the court forced, I cannot decide that issue here. File an application for review.
But without filing this application, from the record, I cannot found this application, Lordship.
Why?
Because without
The allegation is that the court forced you to withdraw. I cannot decide that issue here. Whether the court forced you to withdraw or not cannot be decided in a revision application.
when the application was withdrawn, their application is not in the record. So I cannot prove that.
Your allegation is that court forced you to withdraw.
Lordship,
File an application for review.
on the ground, Lordship, because on the ground that
So that is the law.
on the ground that the
It does not appear from the record that the court forced you to withdraw.
No, Lordship,
Say so, please file an application.
kindly see, Lordship, on repeated call, decree holder, Lordship, kindly see the order.
Yes.
On repeated call, decree holder, namely Babulal Sharma, is found absent in courtroom.
Yes. No show cause reply by the decree holder.
Babulal Sharma,
Filed till now.
till
No.
Lord,
Review, I can give you liberty to file a review. This cannot be interfered with. If you have not filed any show cause petition, nothing.
the two petition filed by the learned council, namely,
Press the same in open court.
Lordship, kindly visualize the situation.
No. I cannot visualize anything. If you want, you can file a review there.
Lordship, kindly giving the liberty to.
After some argument, the learned advocate
My lord, item number 27, 28, and 29, I'm praying for a week's accommodation.
not this week, next.
I am for the petitioner, Lordship. Learned advocate on record is that
What do you want?
I want to fix this matter on Monday, Your
Not
Lordship.
today, next. 31.
May I plead your lordship, my lord?
Yes.
But this is an expeditious disposal of appointment of survey commissioner that has been allowed by order dated 18/6/2024 by learned civil judge junior division Bidhannagar, North 24 Parganas. With learned civil judge junior division Bidhannagar,
what is the suit for?
Suit is for declaration and permanent injunction, my lord, where I have stated that the defendant.
Awaiting report.
Yes, my lord.
So commissioner was appointed.
Commissioner is appointed by order dated 18/6/2024, but that has not been done by learned civil judge senior division second court Barashat, my lord. It is supposed to be done by learned civil judge senior division Barashat, my lord. So I am praying for expeditious disposal of appointment of the survey commissioner, my lord.
No, appointment has been done.
Yes, my lord, it has been done, but the report has not come, my lord. For that, the suit has been delayed, my lord.
I am paying for not today, my lord.
Not today, you are opposing the pair. He is paying for not today.
We are appearing for the opposite party. That's the only.
What do you say?
Not to oppose করে কেউ?
He is paying for not today, you are saying I am opposing.
Opposing not the prayer. Opposing the application.
Not today, next.
Order of
Want an order?
Item number 33.
That stage is over, Mr. Rai.
Every time. We are the daily laborer, my lord. Running from pillar to post.
That stage is over. Not today, next.
Item number 34.
Item number 34, Mr. Devrut Chaudhary is appearing for the Mr. Devrut Chaudhary is appearing for the petition and praying for not today, my lord.
You are here.
And I am not briefed in this matter.
You are not briefed. I am giving you the brief.
Kindly,
Not today, next.
But,
Number 35.
Lord, I appear on behalf of the caveator opposite party. Lord, is from the Baripur court and Mr. Chakraborty is appearing.
Who is for the petitioner?
I've just informed by his clerk that Mr. Chandan Mishra is appearing, my lord. He has not come, my lord. Sir.
So I am not.
My petition, my lord, had directed me to serve. My lord, out of 4 who has received and 2 has come, my lord, in the same address we have served what is given in the plaint. But it has come back as insufficient address.
Then we have
Who have received? Who have received.
But
Main persons have received, but it's a plaint address. Plaint has been, my lord, has been filed in the with that so-called address. My lord, we have no better address than that.
serve upon the learned advocate for the plaintiff. Serve upon the learned advocate for the plaintiff. They are the plaintiff.
No, they are not.
ওখানে কে আছে?
They are not that. They are the dependent.
They are the defendant. You are the plaintiff.
No,
They are the
they are the
plaintiff.
plaintiff.
Other
That
two
is
are-
why I am saying. So
Court-order,
the person
below
which came back with the remark that
plaintiff has received. Dependent number 2 has received. Dependent number 4 and 5 has not received.
4 and 5 has not received. But it's the address mentioned.
Address
Who are
mentioned
you?
in the plaint in the dependent number 4.
I am the defendant there, contesting defendant.
3 and 4.
Yes, have not received.
So the defendant number, which defendant has not received?
3 and 4, na?
You are 3 and 4.
No.
কারা কারা পাইনি
Petitioners are defendant number 3
Yes,
and 4.
but it is not ভট্টাচার্য কত নম্বর আছে? আচ্ছা আমার কাছে আছে
Is which defendant?
give me a moment Miller page 2
Is defendant number 5.
5 yes Nandini and Joyশ্রী
Joyশ্রী is 2.
yes
Are they appearing in the suit?
appear করছে ওখানে
Appeared in the suit.
That I have to check.
If they appeared, I serve upon the learned advocate.
it has come back with insufficient address but it's the same address.
Can you not serve upon the learned
Yes, I
advocate?
can. Very well.
What is the order impugned?
The order impugned is order 7 rule 11.
Rejecting your order.
Order 7 rule 11 on the ground of limitation. Millet 5 millet a unregistered document of millet 86. Millet specific relief millet
Is that matter?
that matter. Yes.
Now, my lord, it was my lord, I had taken, my lord, the interim order was refused. When they moved, the interim order refused, that means it's barred by limitation. Now, my lord, immediately I came back with order 711 on the ground of limitation. My lord, order 711 was rejected.
You serve upon the learned advocate. The learned Mr. Dasgupta, learned advocate, appearing for the petitioner, submits that the registered envelopes addressed to the opposite party number 2 and 4. Please
4.
check up.
2 and
4.
Yes.
Returned with the
2 and 5. 2 and 5. 2 and 5.
Two opposite party.
Opposite party, no, so sorry. Joyce 3 and 4.
Party number
3 and 4. 3 and 4.
3 and 4.
3 and 4.
3 and 4. Returned with the endorsement, double inverted comma, insufficient address.
They are not appearing in the trial code.
Insufficient address.
They are not appearing there, my lord.
Full stop. Petitioner is directed to serve a copy of this application upon the opposite party numbers 3 and 4 afresh, or upon the learned advocates representing them before the learned trial judge. List this matter under the same heading after 2 weeks.
So they are not appearing in the trial code also.
If in the meantime they have appeared, please check up.
My lord, only thing is that matter is on 3rd.
3rd of
November, this week.
Nothing will happen. Order 7 rule 11, let it proceed. Mentality will always be an issue in the suit. Mentality will always be an issue in the suit.
I have done my best, my lord. I could have, I have done my best.
Because if it is insufficient address.
So, my lord, see, is the same address in they have
appreciate that. Make an endeavor. If in the meantime they have appeared, you can also serve.
If my lord gives me limited protection till 3rd.
For what?
Stay of fruit.
Nothing will happen.
3rd, for a day.
Why?
For a day, because I naturally day to will be after that. Next day it will be long, my lord, not before December or January. My lord knows. For a day, my lord gives me a day.
It will be open to the petitioner to pray for an adjournment on the next date. To pray for an adjournment before the learned trial judge on the next day.
Yes.
Yes. Adjournment for the next matter.
My lord, is it my lord pleasure to keep it on record, the envelopes, because it's now original.
Service.
So that's there.
File the affidavit of service. Affidavit of service filed in court is taken off.
My lord, this is my lord along with the affidavit of service.
You file the affidavit of service only.
Very well. Very well. Let it be kept on record.
Yes.
Obliged.
Lordship, I am for the petitioner.
Yes.
Lordship, in this case, Lordship, petitioner, the applicant in that code below have filed an application under Section 8 of the West Bengal Land Reforms Act. And the next adjacent landowner, my lord.
You are the preemptor or the
preemptor?
Preemptor, yes.
And the
preemptor. Preemption application dismissed.
Dismissed by both the courts. By both the courts. On the ground that earlier in 1975, my mother has purchased this land. There are two parts of the land, Schedule A and Schedule B. Schedule total 5 decimal of land, 2.5 owned by my mother, and 2.5 subsequently in the year 1976 owned by the mother of the opposite party number 2. And thereafter, in the year 2020, opposite party number 2 has sold out the Schedule B party to opposite party number 1, the PMT. So, in this situation, we have raised an application within the time that October so December
Ground on which it was rejected.
ground that earlier it was not, we have not exercised the right of preemption at the time of 1976 purchase. And so that this is limitation bar. This was, both the court has ascertained this point. Held.
What is the law in this regard?
Lordship, in the preemption,
Waived your right.
Yeah, my lord.
Of the first transfer, whether you can file an application for preemption on the ground of second transfer. What is the law in this point?
My lord, in the preemption, every new subsequent purchase, there are subsequent cause of action, my lord. And so that the subsequent.
There is a direct decision on this point.
Direct decision, my lord, I have 1978, my lord.
What does it say? What does it say?
Paragraph 15, my lord. Finally, may I read, my lord?
Paragraph
15, my lord.
Yes. Yes. Show me the finding of the learned appellate court. So this is a judgment of affirmance. Show me the finding of the appellate court on this.
My lord, decision with reasons.
The appellate court has not discussed.
Appellate court has not discussed.
Where is the trial court's judgment?
Page 70. 71 is the ordering part. 71 page inner page 6, my lord, running page 71. 71, my lord.
The application for preemption Not today, next.
Number 39.
39, you are appearing.
Lordship.
You are appearing.
39. Lordship, this is husband filed matrimonial suit for divorce. And Lordship, this is transfer petition. Transfer petition, Lordship, it's a matrimonial suit from
Section 24, I do not have determination.
Lordship, I have stated court number 25, Honorable Justice Sharma, but somehow the case has been published on Lordship's court.
এটা এখানে এলো কি করে?
Appropriate bench, Lordship.
আচ্ছা ওটা কেটে দিন। Let the matter be placed before the appropriate bench.
Grateful, Lordship.
Yes, next. ওই ওই appropriate steps টা কেটে দিয়ে লিখুন in view thereof let the matter be placed before the appropriate bench. Registry করে দিন। In view thereof the registry is
Lordship, item number 40, I am praying for a not today, Lordship.
Not today, next.
Kindly take up the matter on Monday, Lordship.
Not today is Monday.
Malad, in item number 41, Malad, this is a section 24 application, Malad. But in my presentation form, it was written, Malad, code number 25, but it has come here.
It's a what? 40 also.
Same order. এটা কি করে এখানে চলে এলো কি করে এগুলো?
My lord, I appear for the petitioner, my lord.
Yes.
I'm praying for not today, my lord.
Why?
And the brief is not with me, my lord, today.
Take my brief.
My lord, kindly. 42 and 43, my lord.
42, 43, not today, yes.
I'm grateful, my lord.
All I have for the petition.
Yes.
My lord, appeal was preferred against an order of a demolition of a portion of a building. It was preferred in the year 2017 November.
218 subsection 3.
No, it's 415 KMC Act.
KMC Act.
KMC Act.
So we went before the tribunal.
We preferred an appeal in 2017 November.
Is what happened? Appeal dismissed.
Now there was a delay. We filed a section 5 application also.
Condonation rejected.
Condonation rejected in 2025. In the meantime, appeal was admitted, 1 lakh rupees was imposed as the cost. I paid the charges. Stay was granted. Matter was ready for final hearing. On the last stage, the court finds that the section 5 has not been disposed of. There is no space order. So on 6th August 2025, my section 5 is rejected. After the lapse of 8 years, I paid 1 lakh rupees deposit also. Stay was granted for admission of appeal. Condition was put that if you want to pay for stay, you put 1 lakh rupees cost. I put it. Stay was moved. Stay was granted.
In 2017, 8 November, I'll show you the order, Lordship. Kindly see. The order of stay is on 8 November 2017.
Stay was granted.
Yes.
Appeal was admitted. Show me the order admitting the
8 November 2017.
8th November 2017.
Lordship. And Lordship, the order ends.
No, 8th of November, it says, what is the, where is the order?
Let there be an interim order of stay of operation of the impin order. It's a full page order. This is how they have given me the certified copy. If your Lordship will allow me, Lordship, I'll find out and give it to you, Lordship. It was impin order was stayed. It was extended time to time. There was a direction to deposit 1 lakh rupees as the security which I deposited.
What is the period of delay?
Period of delay was, Lordship, just a minute. I'm sorry, Lordship.
200 days. More than 200 days.
No, what happened? When we filed the Section 5 application, there was no specification of the delay. The court found itself unilaterally is more than 200 days. And the court rejected my application in 2025. But the thing is that by appeal was admitted, stay was granted, 1 lakh was paid cost. It was ready for the final hearing. After 8 years, it has been rejected on the ground of that there was no order passed in Section 5.
The grievance of the petitioner is
Me please, Your Lordship. This is my application, my lord, essentially praying, my lord, for expeditious disposal of a commercial suit pending in the Alipur Commercial Court. My lord, I am the owner of a 5-story building in Park Street. 5 floors, my lord, have been given out on lease to, my lord, the opposite
What
party
is the
herein.
stage of the suit?
Written statement not filed within time. Interim application filed by me allowed so far as payment of occupational charges is concerned, arrears is concerned, nothing being paid to me. Order of injunction.
Have not filed the written statement. What remains? It will
Nothing. Last date was in August. Next date is in November. 3.5 months is been.
It's a holiday 1 month.
1 month is holiday, but 2 months, nothing is happening. The suit can be finished off expeditiously, my lord.
So suit
There are
of,
5 separate suits filed by me for each of the floors.
it's a suit of 2024.
Yes, I admit.
So
It's a commercial suit, my lord.
commercial suit, I appreciate it is proceed.
Yes. Only issue, my lord, is the long dates which are passing by with no action being taken, my lord.
Long dates, 1 month was a holiday.
1 holiday.
August,
2 months.
entire October is within holiday.
Yes, so
The other matters also have to be adjusted.
I know. So August, September, 2 dates, full months went by. I bow down so far as October is concerned, 1 month pujas are concerned. But there are 5 such suits. None of the matters when written statements filed. It was a hospital. Hospital was stopped by an order passed by this court, my lord, in a separate proceeding. Contempt was also filed. About 7,500 square feet, my lord. Prime location, a dilapidated condition, sealed by Kolkata Municipal Corporation. I am suffering, my lord, for no fault on my part. I am not asking for anything extraordinary, my lord. All that I am humbly praying for, my lord, is let the suit be disposed of in accordance with law within any time frame which may be fixed by your lordship.
ছোট যেন লিস্টে থাকে।
Lord, 46. I am the owner of a commercial property, my lord. I had entered into a license agreement with the opposite party, plaintiff. My lord, owing to differences, non-payment of rent, I invoke the termination clause. The opposite party
What is
plaintiff.
the order impugned?
My lord, the impugned order is at page 58. My lord, it's for police help. My lord, he files a suit, obtains an injunction. I file a misappeal.
Police help allowed.
Police help allowed, my lord. My lord will, without any record, my lord, without any police complaint on record, without any complaint on their part. And my lord, in the order, if my lord reads, the order has been given, my lord, the order gives a very wide power to the police. The police has been, my lord, it reads, but how police deals with it, I understand, my lord, that is subject matter of writ court. But as far as this order is concerned, this is dehouse any reasoning. It just somehow vaguely says that there is a complaint. It reads, my lord, and my lord, I have failed to appear in to file my wakalatnama and file my written statement. However, my lord, I attempt to contest this petition, which was rejected. It was heard without contest. My lord will kindly come to this part. In this case, by order dated 6th, order number 6 dated.
Where is the order of injunction?
My lord, the order of injunction is at, my lord, page 34, my lord. It application to police help application to the police help. And my lord, the application on the basis of which the impugned order is passed, that my lord will find that
It was inducted into the property as a licensee.
As a licensee, my lord.
So how can you disturb his possession during the subsistence of that license?
My lord, what happened, my lord, is due to non-payment of rent. Due to the non-payment of rent, I invoke termination clause.
Maybe, but
he
he or she has not yet been evicted by due process of law. You can evict her.
Absolutely.
But how can you create
My lord,
disturbance in the
my lord, what the police has done, police has gone and put a padlock. My lord, those police has, my lord, the police is, my lord, at page 115. My lord will see what the police is doing. My lord, I understand this is subject
Have you
matter of
taken
police
possession
overaction.
of the property?
My lord,
Have you taken possession of the
no, my lord, I am not. I have not taken possession of the property.
How are you aggrieved? If they are in possession, police has put a padlock. It's they who are the aggrieved person because they are restrained from entering. You cannot be an aggrieved party. You cannot be an aggrieved party.
My lord, perhaps, my lord, but my lord, my access to the property is also restrained, my lord.
How?
Well, as a landlord, I have my access to the property, my lord, by way of agreement.
The opposite party is in possession of that property.
Perhaps, my lord. My lord, it's a license agreement, and I can have my access after due notice. My lord will see what it has.
Who are the advocates appearing before the trial court?
My lord?
Who are the advocates appearing in the trial court? You know the learned advocates who are
My lord, I'll have
representing
to.
the respective parties before the trial court.
My lord, I'll have to seek instruction on that.
Take instructions.
I'll come. I'll come back.
Not today.
I'll
Matter you have brief.
Yes.
You have instructions also to move.
Yes, madam.
Yes.
Petitioner is a plaintiff in a suit for partition.
What is the impugned order?
Madam, I'm coming to that, madam. An ad interim order of injunction was passed on 1st of July 2025, my lord. Nature of status quo and not to change the nature and character of the suit property. Thereafter, my lord, the defendants continued with the construction, my lord. I have filed an 151 application. Initially, that was allowed. My lord,
151 for police help.
Yes, my lord. If my lord kindly comes to my lord, page number 22. My lord, this was the order, my lord, by which my 151 application.
22.
Yes, my lord. My lord has got it.
Yes.
By this, my lord, my application for for police help that was allowed. But even after that, my lord, the defendants continued with their construction. My lord, I have filed another 151 application.
Yes.
That was turned down, my lord. Against that, my lord, this civil revision application was prepared. Now, my lord, the court, while no, my lord,
When
this was the earlier.
order was passed, why did you file another application?
Because, my lord, they are still continuing with their construction. My lord, there was a direction.
Order is there.
Yes, my lord, I have communicated that to the
Where is the
police.
impugned order? Show me.
Yes, my lord, that is in the certified bunch of the certified copy, my lord.
What is the date of the impugned order?
17th of September, my lord.
17th of September.
That is the page number 7 of the bunch, my lord.
17th of Yes, 17th of September.
If my lord kindly comes to the middle paragraph, my lord. It has been submitted by the plaintiff that for proper implication of the ad interim order of status quo passed by this court on 1st of July 2025, necessary direction has already been given to the IC Chonchal PS and compliance report has been called for by the concerned PS. But the defendants are continuing with their attempts to change the nature and character of the suit property by violating the ad interim order of injunction. And although the plaintiff submitted his written complaint to at the local PS, no action has been taken by the local PS. I am agreed by that, beloved. I have communicated the order dated.
Compliance report has been, date has been
on
fixed on
22nd of December, my lord. My lord kindly looks at these photographs, my lord. Dada, Lord, kindly have a look at these photographs, my lord. Even after passing of the ad interim order of injunction, which has been communicated to the defendants, they are still continuing with the construction, my lord.
partition suit.
My lord, I understand, my lord.
You are the plaintiff.
There is an order of
You
ad
admit their share. They are the co-sharers.
Lord, there is an order of ad interim injunction.
Value of the property will increase.
My lord, I do not want that, lord.
You get that property, that constructed portion.
My clients are not
claim any equity.
My lord, my clients do not want a construction over
Because you have a constructed portion.
No, my lord, nothing. My lord, when I have brought it, it is a vacant land, my lord. I can show from the deed of sale, my lord. My lord, kindly direct the police to keep a strict vigilance to ensure that. My lord, police are not acting on that. My lord, police are not complying this order, my lord. Now, this is the court's duty, my lord.
By the order impugned,
দিয়ে দিচ্ছি আচ্ছা ভাই
I'm a peer for the opposite party. I've been served an hour ago. I've been served an hour ago.
You have been served
An hour ago.
an hour ago,
Yes,
not
on the last
today,
day.
next.
Then, my lord, this matter will be fixed on, my lord, next Wednesday, my lord. Wednesday might be taken up, my lord.
Not
Just
today.
prayer, my lord. If we have also filed an application on expeditious disposal, if that can also be taken up together.
All right, I'm making it not today only. Yes, next.
I'm good.
49, London Advocate Superior Hotel is appearing on behalf of the.
Not today, next.
Lord, I'm on the caveat that I'm not being served with any copy. No, Lord, I'm ringing up number. Before vacation, my Lord, he has ranks, but that time I left for home. But now, today, my Lord,
You have not solved the caveat.
yes, yes, suddenly. আমি দিয়ে দিচ্ছি আমি এক্ষুনি দিয়ে দিচ্ছি
Fixed on Monday, but
Should have served him beforehand.
yes, before vacation I have it is
before he had
and in the morning, since morning well I have tried well I could not
You serve him in the morning. How can he get
that
himself
is
prepared?
that is before
Also
vacation
cannot take instructions.
yes, that's true.
So
Before vacation I informed that he has left the court.
exactly by that time I left.
Order 6, Rule 17 allowed. Order 6, Rule 17 of plaint or written statement.
Plain.
That's not the time.
Plaint allowed.
Yes. Now, my lord, this is a different suit for partition and declaration filed by the plaintiff. Defendant claiming to the exclusive owner of the property by way of counterclaim and for eviction of the plaintiff. There are two brothers, my lord. In such a suit, my lord, I am drawing your attention only one thing. What is the status as made by the defendant in their counterclaim? Can you turn to page 22, paragraph 11. So it is a suit for a recovery for page 22.
22 is the written statement.
Yes, yes, yes.
Counterclaim.
Counterclaim.
Page 22.
I've got it.
Yes.
Last paragraph 11.
Plaintiff is a trespasser.
So therefore, a suit is based on title the trespasser. Now, what is the amendment sought for? Can you turn to page? Yes. That the defendant have
page.
Yes. And you turn to page.
Prior to that, there is
Yes.
amendment.
We'll come back.
Page 35.
35. Yes.
Usually it's page 37.
37, yes.
Huh? Action.
Yes.
And the cause of action for 2021, whether the counterclaim can be considered to be a cause of action is subsequent to the filing of the. Can you turn to the last paragraph and the necessity for the purpose of deciding this issue?
No, the suit filed when?
Yes.
The written statement filed when?
Suit filed by not in 2015.
Suit may not be relevant. The written statement filed.
Written statement filed. Was filed on 15/6/2015. B at the 15/6/2015. Right hand top. My lord will find
6/2015. Written statement with counterclaim filed.
Filed. B and it's a B page 21.
All right. So, but here the cause of action is subsequent to that date.
Yes. How it can be considered.
All right. Serve him a copy.
Yes, that's so.
Yes, I saw it. You can take my copy also.
Do not have an extra copy.
No, where? Yes, my laboratory also has the.
From your serious stuff. You do not have caveat, you do not have an extra copy. How can you serve him?
It was there.
Vacation is passed by that time he can send me by post.
Yes, could have sent him by post.
So
Let it be hard on Monday, my lord, I am not. Let it be hard on Monday.
I am giving the copy.
Serve him a copy in post of this day.
আপনি নিন আমি
You are giving your filing slip also, Mr. Rai. What are you doing?
Yes.
Give him a copy.
Yes, just
Not today, করে রাখুন।
not. The next date is fixed.
27.
But Mr. Rai, there is a caveat.
That he praises them. I am not asking anything.
I cannot pass any order of stay. Because caveat he has to get himself prepared. I'm making it not today. Right, that's it. Sir, I have not recorded it. Please ensure that the
Yes, certainly, it's my duty.
Yes, please ensure. Don't keep it to your juniors. You personally see that it is.
Yes.
Premi just made a rather ardent but sort of bold prayer. My learned friend is there. Item number 52, your lordship.
Item number?
52, your lordship. Of today's this was the matter. Mr. Suddha Banerjee was leading me. Mr. Aniruddha Chatterjee was appearing on the other side with respect to the order passed under Order 23, Rule 3, Sub Rule 1. Your lordship had heard the matter, but due to paucity of time, it could not be completed. Your lordship, just in the meantime, steps have been taken to file the suit afresh before the competent court. Your lordship, just it will become infructuous on Monday if your lordship's time permits.
Monday it will remain in the list.
Mediation is in process.
The mediation mediation is in the process. That is the
Heavens will not fall. He said heavens will not fall.
So it will be given some priority on the top.
Yes, Mr. Aniruddha Chatterjee is also visible here. Sometimes visible, but not in his robes. Mr. Chatterjee is
My
not.
lord, that's a picture, my lord, comes from somewhere, I don't know where.
No, your lordship. Hateful.
গোমচির বাড়িতে